All right, so welcome everyone. It's great to see so many faces, so many familiar faces as well. For those who don't know me, I'm Henning Gross-Ruiz-Kahn. I'm one of the directors, the co-director together with Lionel Bentley of the IP and Information Law Institute here at Cambridge. So this is the first of our seminar series in the new academic year, and it's sort of great to kick it off with someone no less than Dan Burk from UC Irvine, right?
Yes.
And I think I met Dan in the context of something completely different than algorithmic fair use. We were sort of on patent law, international patent law, and some sort of a Max Planck declaration, and whether we got it right in terms of what exceptions are allowed and everything under TRIPS. So Dan supported us on that project, and that's how I came to know him some years back. So he's here at the moment in the UK, and I understand you're not meant to leave the UK.
That's right.
For the whole of the term you're here, based on that UK Fulbright scholarship conditions.
That's right. Stay on the island.
On the island, yes, important.
Well, I might be able to go to Northern Ireland. But,
yeah. Well, we can maybe clarify the details about that later. Anyways, Dan is going to be talking about algorithmic fair use today. So my understanding of that is that we're essentially looking at machines who are making our decisions instead of us, or maybe we have to train the machines to make the decisions which we as lawyers might do, and whether they're going to put us out of business in terms of, well, applying the law or maybe even creating the law, right? So Dan, I hand over to you, and we'll all love to hear from you. Thank you.
Thank you very much. Well, I am delighted to be here, and I appreciate Henning and Lionel organizing. I'm particularly happy to be here because when I proposed this topic, I found out that Neve Elkin-Corin was here giving, I think, a major lecture back in the spring on a related topic. So you kind of pointed me to some more literature that I could think about in this area. It shouldn't be any surprise to you, right? You know what Henning has just described to you. You know that we are living in what Jack Balkin now calls the algorithm society, right? So there are computer programs, there are algorithms that decide on the commercial end, you know, whether you're going to get credit, whether you're going to be allowed to have a credit card, whether you're going to be allowed to make a purchase. I bought my ticket to come here a couple of days ago, and my credit card company immediately texted me and said, there's something odd in your purchasing pattern. Did you really buy, what is it, Great Western, Great Northern, whatever it was, railway ticket? And I said yes, you know, but that had been flagged by their automated systems. Increasingly, you know, whether you're allowed to get on an airplane, whether you're considered to be a threat to national security, is decided by these algorithms. A colleague of mine from the University of Washington called me last week and said, I'm having trouble flying. Apparently, I've now been put on the search everything in her luggage list, so it takes her 20 or 30 minutes longer to get through security than it used to because something that she did tripped the algorithm. So lots and lots of this going on around us, lots of people thinking about this, and in our little corner of the world, we want to think about this, how this works in terms of copyright, and how it might work in terms of copyright. And so this is a fairly short paper that I'm trying to accomplish a lot of things. First thing I'm trying to accomplish is to extend some work that I did with Julie Cohen almost 20 years ago now, on fair use infrastructure. At the time we were thinking about digital rights management or TPM systems, technical protection systems, and was it possible to build into those systems some type of copyright exceptions, like the American fair use or UK fair dealing. So this is kind of an update or an extension of that work in some sense. I also am trying to connect the legal discussion to what is a large and growing literature thinking about these problems, right? Since we're essentially surrounded by algorithms that are making decisions about our lives, whether you get credit, whether you can fly on the airplane, whether you're allowed to immigrate to a country, and so on. A lot of people are thinking about this in communications and social sciences, in cultural studies, certainly in computer science and informatics. There's some discussion about this algorithm problem in the legal literature, but it's not very well connected to what is happening elsewhere. So I think that that's an important thing to do. And one of the messages that you get when you read that literature, at least as much as you can stand to read, because it's gigantic, there are entire journals now devoted to this, is technology changes, but humans and human institutions really don't. Right? So we may be able to tell something or know something about how we can and should react to this. Even though the technology is new, people are pretty dependable in their reactions, right? And of course, that shouldn't surprise us. That's what social science and the humanities is really based on. But I want to connect the legal discussion to those broader literatures. I also want to push back on what's been called techno-utopianism or the magic worldview. I'll give you an example of that here in a minute. There's a little bit of it in the paper, but there's sort of a group of people writing who say that this is the future, and the future is going to be just sort of amazing. We're going to have these intelligent cars, and we're going to have intelligent algorithms that will create new law for us, and it will be much better than having human legislators do this. This is all kind of bullshit, right? But I want to push back on that a little bit by using copyright as a case study, right? Because we have some pretty good literature, some pretty good scholarship that we can think about the copyright situation, and maybe will help people who are thinking in the areas of immigration or criminal law or commercial law or these other areas where the same processes are taking place. If you have a chance to look at the paper, or hopefully by the end of this discussion we'll have this evening, you'll see I want to try and refocus the analysis away from, in the particular place that we're looking, particular copyright questions that we're looking at. I don't think that the right question is whether you can automate fair use or exceptions or fair dealing. There are people who are interested in that. One of them is Neve Elkin-Corin, who's published a very interesting paper on that now. I think that's the wrong question, right? Looking at this broader literature, I think the right question for us is, what happens to copyright exceptions when you try to embed them in technical measures? Right? It's not can you do it, because the answer is clearly no, you can't. But what happens when you try? Right? What will the effect be on the law? And I think there's some very interesting literature out of communications and anthropology and sociology that helps us with that. Right? So as I say, that's a lot to try and do in a 20-page paper, but it's at least a first cut at that. Okay. So as I said, there's a very big literature, a lot of discussion, and a lot of personal experience that everyone in this room, I believe, at this point has about interacting with these automated systems at some level. And as I said, they're appearing across lots and lots of personal experience domains and lots of legal domains. Right? Should we grant bail or should we grant parole to a criminal offender? Right? More and more, that depends on computer systems, on algorithms, what they expert systems suggest about the behavior of a criminal offender. Should we allow this person to immigrate to a particular country? Right. Well, again, there's an expert system that's probably trying to vet the data that's been collected about that person, figure this out. So, happening across a lot of different legal domains. In the copyright area, where we want to focus, this is playing out on the internet, right? On the platforms that you're familiar with, in ways that you may or may not have noticed, but which probably won't surprise you, right? So algorithms are being deployed, right? Computer systems are being deployed in copyright enforcement on YouTube, on Facebook, on Twitter, right? Lots and lots of these platforms that you're familiar with, in a variety of different ways, right? Again, some of which I've experienced just this week, right? I went to view an embedded video in the Washington Post, right, U.S. newspaper, and it popped up and said, "I'm sorry, but the copyright holder has not authorized viewing of this video in the country that you are in," right? Because there was not authorization for it to be streamed to the UK. So I logged into my VPN, right, so that then it thought I was in California and I could watch it just fine, right? Something's monitoring my IP address, right? There's an algorithm that's monitoring my IP address. So there are filtering algorithms both for uploads and downloads, right? You know, YouTube has algorithms that watch for what might be copyright infringing content being uploaded to their system because it's just a pain to deal with it once it gets there, right? Or if there's material on their system, they may have an algorithm deployed that will block the download or the access to it, especially depending on what jurisdiction you're in, what it thinks your IP address looks like, or who it thinks you might be. Right? The content owners, right? Copyright owners, the music industry, the movie industry, other copyright owners, they have deployed robots, right? Algorithms to troll the web, particularly platforms like YouTube or Facebook, looking to see if their copyrighted content is showing up there without authorization. And you may have seen some of the funny stories, maybe they're not so funny, ironic stories, right, of them demanding that YouTube or Google or whomever take down infringing content when it turns out that they themselves put it up there. Right? It's like, there's infringing movies on this site. Oh, well, it's the Universal Pictures site. That's why it's there. But the algorithm doesn't know that. It just recognizes a match, right? So, the bits that I've been told to look for are the bits that I found on this particular website. So the content owners are looking, demanding removal of what they think is infringing content. And this is mostly, there are a variety of ways this is done, but frequently on the basis of so-called digital fingerprints. Right? So I sort of do a hash, I do a compression of a particular song or movie or copyrighted work, and the robot goes out crawling the web looking for that. And if there's a match, you then demand that it be taken down, or you, if you are a platform, sometimes you will take it down because it's easier just to do that than to deal with the possibility of litigation or the hassle that you get from the copyright owner. Now, my friend Matt Sag, who was at Loyola University in Chicago, has done a very extensive study of these different mechanisms. And in a forthcoming paper, he says, not surprisingly, that the behavior of users has changed, right? The behavior of platforms has changed. We're dealing with massive amounts of content, right? Terabytes, petabytes of material, most of it subject to copyright, and monitoring and policing and keeping track of that is difficult. And so you have automated systems, right, that have been deployed to deal with that. And for the most part, this has become de facto judge, jury remedy. Right? The copyright owner or the platform, whoever has deployed the algorithm, detects what they think may be infringement. The material comes down. There are huge asymmetric costs, right? Even if there was a legitimate reason for it to be up there, most of the people who have put the material up on the website or on the platform don't contest the takedown because it's expensive, either in terms of personal effort, time. Certainly if you get into a litigation situation, it becomes very expensive in terms of court costs and attorney's fees and so on. And so the robots are making the decisions. And people know this, right? So they have changed their behavior. Either they won't put things up, or if they do, they will try and put them up in a format that won't get detected, right? Or they'll put them in a place that they think won't get detected. This is kind of an old example. This goes back a ways, but one of the earliest examples was on the peer-to-peer file sharing networks, like Napster or Grokster back many years ago, when primitive versions of these algorithms, began looking for infringing files, people would change the designations on the files. They wouldn't put Britney Spears on, BRTN SPR, right? And in the hopes of fooling the robot, right? Well, it doesn't say Britney Spears, it says Burk. A human can recognize that, the robot didn't recognize it. There are more sophisticated versions of that going on now. So people have changed their behavior. Copyright owners haven't really changed their behavior. They still want to enforce their copyrights. But they're doing it sort of wholesale, right, en masse. And certainly the platforms have changed their expectations and their behaviors. And Matt Sag worries, right, that we essentially have a new type of copyright regime. We used to think that copyright was sort of defined by the legislature and enforced by the courts. You had a parliament or a Congress, who sort of decided what rights were, and then a judge who decided how to apply in a certain case. This is all becoming privatized, right? It's all sort of happening at a lower level, almost never rises to that level, unless somebody has a lot of resources to commit to getting a legal judgment. So these robots, right, these algorithms that are looking for infringement and that are, sort of detecting and executing remedies for infringement, none of them really incorporate any of the scope or user privileges and exceptions that we think of being associated with copyright. Right? As I said, the robot is just looking for a match, right? These are the bits I was told to look for, and I found something that matches those bits, and so it comes down. Right? And there's really not any attempt to incorporate into this. Is it mostly functional or factual? Is it there's sort of an idea expression thing going on here? Is it private use? Is it for the handicapped? Is it news reporting or educational use? Right? Those things are not built into the system. And many of you are aware or familiar with these kinds of exceptions that they sort of fall into two buckets. I'm going to put them into two buckets. One is the sort of UK Commonwealth fair, what I'm going to call fair dealing, right? where you have a laundry list of exceptions, right? And that's what most countries in the world do. Is the copyright owner has exclusive rights, but there are certain situations where you can use or make use of the material without the copyright owner's permission under these discrete and defined circumstances. If it's news reporting, if it's a quotation for scholarship, if it's educational, right? The Information Society Directive has, I think, 28 laundry list of 28 possible exceptions, if I remember correctly.
There are lots of ways to count them.
Well, I mean, the way they got the list was they sort of looked at what all the EU member states had, and they just threw them all in there and said, pick whichever ones you want. Right? If I remember correctly, France has an exception for news reporting, which the Netherlands doesn't have. Netherlands has one for education, which France doesn't have. The Scandinavian countries have exceptions for people who are visually impaired that the French and the Dutch don't have. Everybody has their own list of exceptions. The United States has a few of these, right? As I mentioned in the paper, my personal favorite is the personal exception, the exception to perform non-dramatic musical works at agricultural fairs without the permission of the copyright owner. You can think about the lobbying effort that's very important at the state fair, right? Be able to perform music without paying royalties. So we have these, and this is what most countries have done. They try to identify discrete situations where there's an exception to the rights of the copyright owner. The United States and a small number of mostly inconsequential jurisdictions, like Israel and Taiwan, have adopted kind of a catch-all provisions, fair use, right? Which doesn't specify particular situation, particular factual criteria, right? Not a discrete, defined situation, but says essentially we can't predict in advance what situations it might be okay or fair to use the work without the permission of the copyright owner. So here's a list of 4 factors that a court should look at, and this is flexible, right? On a case-by-case basis, according to the facts of the particular case, a court will decide after the fact rather than beforehand, right? The way you would do with fair dealing. After the fact, a court will decide if it was fair or not, and the court should take into account basically how much the alleged infringer took, what kind of work he took it from, what he did with it. Was it for something good like education or scholarship or news reporting, or was it to make some quick money? And what impact will that taking have on the market for the work? Right? So look at those 4 things in any given situation, and it's kind of a catch-all. Larry Lessig says it's basically a right to be sued, right? But I don't know if it was fair use or not. I guess we'll find out once the judge tells us. Which is kind of risky, right? But these are excellent examples of what legal scholars have for a long time talked about in terms of rules and standards, right? And you may have bumped into some of this in the literature. And these names or designations are used for, on the one hand, sort of discrete, bright line legal imperatives, like, drive 60 kilometers per hour, right? That's, pretty definite. It's easy to figure out if you're doing that or not. You look at your speedometer, or the policeman looks at the radar gun, and says, yes, you were traveling 60 kilometers per hour, or you weren't, right? As opposed to a standard, right? Like, drive at a reasonable speed. Drive at a safe speed. Well, how do you know if it was reasonable or safe? Well, that's fact specific, right? It depends on whether it was light or dark, whether the pavement was wet or dry, whether you were drunk or sober, whether your automobile has tires that are new or bald, right? There's all kinds of factors that could go into deciding whether something was reasonable. And these are these have reciprocal advantages and disadvantages, right? The bright line, discrete rule, which Carol Rose in a very famous article called Crystals, right? It's a very hard-edged rule, is easy to enforce. It's easy to understand, right? It's easy to know if you're in compliance. The problem is it's not very flexible. Right? You drive 60 kilometers per hour. I know if I'm doing that or not. I'm driving, at 120. Why? Well, there's somebody bleeding to death in the backseat of my car. I'm trying to get to the hospital. Right? Oh, well, that wasn't in the rule. Right? There may be situations where you'd rather have a more flexible, fact-specific standard. Well, that can deal with situations you hadn't anticipated, like, is somebody ill? Is there an emergency or something like that? But it's also, again, as Larry Lessig says, very hard to know in advance whether you're complying or not. Right? You don't actually know until the judge tells you, yes, that was a reasonable thing to do, or no, that was unreasonable, you shouldn't have done that, so now you're going to jail. Or you're going to pay a fine. They kind of have reciprocal benefits. And the famous Carol Rose article on crystals and mud, right? She says the interesting thing is that these kind of process back and forth, right? So you start with a hard-edged rule, drive 60 kilometers per hour. Okay, we understand that, right? And then you go, but there's an emergency. Okay, well, drive 60 kilometers per hour unless there's an emergency, right? Actually, sometimes that might be too fast. It was really icy. Okay, well, drive 60 kilometers per hour unless there's an emergency or unless it's icy, right? When you start inserting fact-specific exceptions into that rule, right, until it becomes more and more flexible, and it starts looking more and more like a standard. right? And things go the other way too, right? I mean, court will say, well, you're supposed to drive at a reasonable speed, right? So on a case-by-case basis, we figure that out. But we know that it's never reasonable to drive 200 kilometers per hour on any road that we're aware of. So now we have kind of a per se rule, right? Drive at a reasonable speed. We know that this one is never reasonable. So now you start having a rule embedded in that standard, and these, sort of are on a continuum, right? And you can see that in the exceptions to copyright, right? You can say in a situation like the U.S. or Israeli fair use, well, it'll be fair based on how much of the work you took and what you did with it, what kind of work it was, and what it does to the market, right? For a long time in the United States, we had almost a per se rule, though. If it's commercial use, that can't be fair, right? So if you come up with a commercial use, we're just going to automatically say that can't be fair. Now the Supreme Court has since backed off on that, right? But you can see the same dynamic taking place in the exceptions to copyright. Well, why do I spend time on this? Because as you can imagine, it might be possible to program into an algorithm a fair dealing kind of rule, right? So, Section 110 of the U.S. Copyright Act says, as I jokingly but not jokingly said, you are permitted to publicly perform non-dramatic musical works at agricultural fairs without the permission of the copyright owner. Okay, well, could I program that? Maybe yes, right? I mean, if you sort of had a database, a calendar, where the agricultural fair is taking place, and maybe a little GPS information, and some sort of, tag or whatever. Okay, well, you can play this music in this time, in this place, because the data that the algorithm has tells us that you're at an agricultural fair, and it's a non-dramatic musical work, and that's okay. So it may be possible to do that, right? It may be possible to figure out code that will tell you, well, this is news reporting, this is scholarship, or something like that. Even that, might be dicey, but at least in theory it's possible. It's enormously difficult and probably impossible to program standards, right? I want to code an algorithm to detect whether this is a reasonable use, right, or whether this is a fair use. Even judges can't figure that out sometimes, right? And we have no technology now or in the foreseeable future that is likely to be able to do that. Right? This is actually what Julie Cohen and I wrote about 20 years ago. Machines aren't going to be able to figure this out. You're going to have some sort of human review or human institutional infrastructure to give people access to technically protected content, because the computer is not going to know when a particular exception applies. Right? So possible to program rules, because computers like things that are sort of precise and discrete. Not really possible to program standards. Well, Julie and I wrote that 20 years ago. The technology has changed. Right? The question was posed again, briefly, by the United States Court of Appeals for the Ninth Circuit, right, from my home court, the geographic circuit, California, the western United States. In a case you may have heard about, Lentz versus Universal. This is the famous dancing baby case, right, where a mom uploaded to YouTube a video that she had taken, a home video of her baby being kind of cute and dancing around to a song by Prince, Let's Go Crazy. You can hear the music in the background. YouTube was this was actually done by a human, right? It wasn't actually vetted by a computer in this particular case. Somebody at Prince's recording label, was looking for infringing content and found this video with Prince's music in the background and demanded that it be taken down. There was a whole very elaborate system under U.S. statutes for doing this. As I said, Matt Sag finds that most people, don't have the resources to contest this. In this particular case, Lentz, the mom, found the Electronic Frontier Foundation was willing to provide her with free legal services to contest the takedown in order to try and get the test case and get a judgment. And a major question in the case was, did the copyright owner have a good faith belief that this was infringement when they demanded that the material be taken down? And as you can imagine, that creates a problem. I said, we're talking about petabytes worth of material, right? What does it mean to form a good faith belief? You have to review every example of what you think is infringing material and decide, is this in fact the song that we own the copyright to, and is it being used without our authorization, and is it subject to a exception, like fair use or not? Not realistic to do that with all the content that's on the web now, right? And so the court, in passing and talking about this question of having a good faith belief about the infringement, said, in the opinion, we note, without passing judgment, that the implementation of computer algorithms appears to be a valid and good faith middle ground for processing a plethora of content while still meeting the Digital Millennium Copyright Act's requirements to somehow consider fair use. Right? In order to have good faith belief that this is infringing, you have to believe that it's not fair use, presumably. Can you really review, essentially by hand, all the material on the web? Of course, it's probably not. Maybe you could do this with a computer. This passage was part of the published opinion. The court then depublished this passage, right? Removed this from the opinion. Probably because somebody said, excuse me, Judge, we don't have any technology that will do this. This way it's not feasible, right? But it raises the question, right? How do you handle all this content? Right now, Matt Sag tells us it's being handled by just, you see a match, it comes down. That's probably the end of the story. Does that process have to have some sort of consideration in it of the possible exceptions that it might be subject to? Julie Cohen and I argued 20 years ago that in order to do that, a human's going to have to look at that. The court says that's not really feasible. Right? There's too much material. We can't have a human look at everything. Can we find some way for a machine to do that? Well, as I said, the technology has changed. Right? The algorithms that you are experiencing when you try to board an airplane, or when you try to make a credit card purchase, or when you try to hopefully not apply for parole out of prison, whatever experience you have with algorithms. As Marianne Prasad, who is a sociologist at Berkeley, says, computer science gave up on machines that can think. Right? That was the big thing in the 70s. As we're going to develop artificial intelligence. And that didn't work. So computer science gave up on machines that can think in favor of machines that can learn. So that's mostly what we're dealing with now, is we are dealing with programs, right, systems that are designed to recognize patterns in data, right? And we now have massive amounts of data, right, big data. There's actually a whole journal, right, called Big Data in Society. It's all this peer-reviewed discussion of the massive databases that the government, corporations, all kinds of actors are keeping about all of us, and then are available for commercial purchase, much of it. And so these systems are designed to recognize patterns in data and pick out, for example, he doesn't usually buy train tickets in the United Kingdom. That looks weird, maybe it's fraud. Maybe somebody got his credit card number, we better check that. Looking for patterns of purchasing, in that case, to try and protect me and protect the credit card company, but it could have been much more obnoxious, as in the case of my friend who really can't get on an airplane anymore without spending 30 minutes being searched. That's a different approach than what I have sort of talked about so far. Right? We got to try and code an exception into the system, right? We got to try and code fair use or news reporting or playing the non-dramatic musical work at an agricultural fair. Some programmer has to actually write code for that. Now, we say, okay, we've set up a system that can recognize patterns, and we feed it training data. We start feeding data into it, and when it gets it right, we keep that, we enhance that. When it gets it wrong, we try and fix that. And so the machine progressively learns how to find patterns in all of this data. And so the question has been raised by your lecturer back in the spring, among others. Maybe this system could be used to recognize fair use. Right? We have lots of data about copyright exceptions like fair use. Maybe we could feed all this data into the system, and the system could recognize the patterns, and maybe it would, without having to specify in code, having a programmer assign the values as to, this is fair use, this is not fair use, the machine just sort of will figure it out. Right? We would have to break down all of the judicial opinions dealing with fair use, figure out what the relevant factors are, and feed those into the machine. Some people have tried to do that. Right? My friend Martin Beebe, Pam Samuelson, others have tried to find sort of recurring patterns of fact situations that seem to lead judges to decide that it's fair use. Maybe we could train a machine to be able to do that as well. That runs up against a different set of limitations or a different set of problems than trying to get a programmer to specify the parameters of a copyright exception in an algorithm. First of all, there are expertise limitations, as you can imagine. Right? Whoever designs the system is probably not going to be a lawyer. And so there's kind of a translation or communication question, right? Can the lawyers communicate to the engineers what parameters, what characteristics the system ought to have? Language limitations, right? Both in the sense of having a lawyer communicate to the engineer in a natural human language what the law means, and then trying to design a system in a programming language, right, that will be able to recognize that or find that kind of pattern. And apparatus limitations. Right? This is going to happen, this is ultimately going to happen on a machine, right? And the machine has certain capabilities and lacks certain other capabilities. So you've got all those kinds of limitations. The hope is, though, right, that, at least on the part of some people, that the same kind of machines that are supposedly learning to recognize people who are threats to national security, learning to recognize people who shouldn't be let out of jail because they will be recidivists, machines that recognize whether fraud is being committed on a credit card or not, might be able to recognize patterns that add up to being fair use. I've been doing most of the talking. I want to pause here for a second and make sure we're all kind of on the same page. You understand what the shift has been in the technology or the shift in the approach. Right? Rather than trying to define things in code, we define a system and we let the system figure out what fair use or recidivist criminals or other kinds of patterns in the data look like. Make sense? Follow? Okay. All right. Now, as I said, this is happening across all kinds of domains, all kinds of personal, commercial, legal domains, and I get alarmed when I read statements like this, right, from a pair of legal scholars who otherwise seem to be relatively intelligent people. This has been dubbed the magic worldview. Right now, magic being defined in anthropological studies as situations where you get something for nothing, right? And it's sort of costless, right? So talking about a future as run by algorithms, right? They say it's going to be much better right, than what we've had in the past, because human decision makers, like judges, for example, are flawed and biased. The biases and inconsistencies found in individual judgments can be washed away using advanced data analytics. That's the first thing that makes me worried. Even if a machine-produced law is not perfectly unbiased, so long as it is less biased than a law produced by individual humans, the result will be net beneficial. And this actually shows up in the legal literature with some frequency. There's sort of an idea that if we get a big enough data set, right, everything kind of averages out, right? It's like all the problems in the data, all the biases in the data, biases in the system will all just kind of be okay if we get enough data, right? Massive amounts of data. That ain't how it works, right? And hopefully that's, if that's not immediately obvious to you, we should talk about that a little bit, right? As I said, there's a very large literature now trying to understand how society, how humans, how people are coping with being surrounded by and governed by and interacting with these algorithms. And my sometimes co-author and friend Tarleton Gillespie has written a very influential article where he tries to summarize sort of what we know about how people interact with algorithms. And he says there are a number of sort of recurring experiences or themes, right? He says first of all, and he sort of explains it in some detail in the article. I'll try and list them very quickly. I'm most interested in the last couple here. Right. He says patterns of inclusion. Right? What gets into the database and what's kept out of the database. Right. Somebody has to decide that. Cycles of anticipation. Right? When a system is designed, when an algorithm is designed, the designer, the engineer, has an audience or a user in mind. And so you deploy the system, and then, as science fiction writer William Gibson used to say, the street finds its own uses for things, right? People aren't doing with it what you thought they were going to be doing with it, right? So, when you update that system, because every system gets updated, right? Microsoft updates my computer far more often than I think they probably should be doing. But when you update the system, you then sort of say, oh, well, people are actually not using it quite the way I thought, so you tweak it to meet user expectations, right? So there are these cycles of trying to guess who's going to use it, how they're going to use it, and then updating. Evaluations of relevance, right? When you get output from the system, from the algorithm, does it match what your expectations were and what people's expectations were or not, right? And again, if it doesn't, then there are tweaks and you update things. The illusion of objectivity. Most of what happens in these systems is invisible to humans. And so you get the sense, people get the sense, like you saw in that quotation I just showed you, that the system is somehow objective or neutral. Right? Nothing could be further from the truth, but because you don't see all kind of the messy decision-making that you would see in court, you would see in the legislature. Right? The old saying has been, I've seen attributed variously to either Benjamin Disraeli or Otto von Bismarck, right? That you don't want to watch either law or sausage being made, right? That all kind of disappears because, I'm not an informatics or computer science expert, so I don't know what's going on inside the box, but, put some input, it gives me some output that seems like it might be neutral or objective. Patterns of entanglement. Right. Now, this is where we start to get the stuff I'm very interested in, which is that the users of the system become entangled, through these first two or three systems or recursions I've talked about with the system. Right? I deploy an algorithm it gives some output, it's not what you expected, so I tweak it to try and make it more what you expected. Now we start to introduce bias into the system based on what you wanted or what you expected. And then you get the next iteration, and as I keep updating it, right, the users and the system become increasingly entangled until you ultimately produce a calculated public, right, that expects particular behaviors or particular experiences from the algorithms, right? And there are lots and lots of studies looking at everything from thumbs up likes on, Facebook, to Amazon recommends this novel based on the ones you bought before, right? To, as I said, very serious things like, should we give you parole or not? Let you out of prison based on what we sort of know about previous prisoners. These are all concatenated, but they sort of end up with people behaving in particular ways or changing their behavior based on the algorithms that they're interacting with, right? As I said, you may have experience with very trivial examples of this, like, I want to get more thumbs up. I want to get more likes on Facebook, so I'm going to put this kind of material up or behave in this particular way. I want people to, I want to have, like my co-author Mark Wilney, I want to have 5,000 friends, or all these followers on Twitter, and so I change my behavior based on that, right? That's in part what people are doing on the system, but more than anything else is what the algorithm is doing, rewarding you in certain ways for certain kinds of behavior. So the question is, can we apply that to this copyright question, this algorithmic fair use question? Start with that quotation that I showed you, saying, well, if you have enough data, the biases just all kind of factor out. Okay. Clearly wrong, right? As my colleague Jeff Bowker famously once said, raw data is an oxymoron, right? There's no such thing as raw data. Somebody chooses what data goes into the database. The full quote was that raw data is not only an oxymoron, it's a bad idea. The data has to be very carefully cooked, right? Otherwise, it's useless. Right? So data has to be formatted, it has to be selected, it has to be assembled in certain ways. Otherwise, the algorithm can't use it. Right? So someone's already making decisions about what information goes in, what information stays out, what formats it goes in. Right? So this can't possibly be unbiased. It would be unworkable if it were. And one of the big questions, as I said, is when you are trying to train an algorithm to recognize whatever you want it to recognize, whether that is credit card fraud or threat to national security or fair use, use that fits a copyright exception, you have to put data into the system to train the algorithm to recognize what you're hoping it will recognize. Right? There's a nice quote in the paper from a computer scientist, talking about so-called facial recognition systems, right, which are a very big deal at airports and especially in this country with all the CCTV. Right? Can we spot the terrorist? Can we spot the person who's a problem? And he said you have to understand that those are not face detection systems. Right? They don't detect faces. They are patterns of pixels that correlated well in the training data with faces, detectors. Right? So presumably, if we try to want to design a fair use system, right, it's going to be, it's not going to recognize fair use, right? It's going to be patterns of data that correlate well in the training data with judicial opinions that found fair use or found a copyright exception, detectors. It's a very different thing than a judge or someone detecting fair use. So the idea that the data is unbiased or all the biases wash out, that clearly can't be the case. Second, right, this illusion of objectivity that I talked about. is a result of the black box effect, and Jenna Burrell points out very nicely that that is a result of at least 3 layers of opacity in these systems. The first one, my friend Frank Pascal is very concerned about. You can read his book, The Black Box Society, which is trade secrets. Right? If I develop an algorithm that recognizes whatever it is, credit card fraud, threat to national security, or fair use, that's my business. That's part of my business. I don't want to give that code, make it available, or make it transparent to my competitors, right? Because if I keep it a trade secret, if I keep the code opaque, that gives me a competitive advantage. Right? So there's sort of deliberate institutional secrecy that keeps us from understanding how these things work. Secondly, there's an expertise gap. Right? Judges, legislators, lawyers are for the most part not computer scientists. Right? So even if you don't have Google or someone withholding the code, you look at all the code. Here's the whole system. Here's all the data. Here's everything. You aren't probably going to know what you're looking at. Right? That has to be translated by someone who's an expert. And then third and most important for my purposes here is technological indeterminacy. Right? Even if the code is available, even if the whole system is transparent, and you have someone who's an expert looking at them, they can't tell what the hell it's doing either. Why not? Well, first of all, remember that we're using technologies that essentially self-define, rather than saying, this is what a terrorist looks like, or this is what fair use looks like. We give the algorithm a lot of data and say, okay, you figure out what patterns are recurring in this that might indicate a threat to national security or might indicate fair use. It's not clear how the machine does that most of the time. Right? So if you talk to people, for example, at Google who are working on self-driving cars, automated cars, they're avoiding this technology like the plague. Right? I mean, as they put it, one engineer put it, he goes, we don't use machine learning because we don't know what the machine is learning. Right? It's like we're feeding it stuff and it learns things, right? So where there's a lot of money or a lot of safety at stake, we don't do this, right? Because we don't know what's happening inside the box. We can't tell. That's the first problem. Second problem, as I've already indicated, no system ever goes without updates, ever goes without maintenance. Right? So whatever you thought you designed it for in the first place, whoever did the design in the first place, somebody else is going to have to update the system. Right? And after it's been through enough hands, it may be very difficult, if not impossible, to tell what is going on because of all of the patches and all the different updates that have happened. Right? That's the second problem. Third problem is network complexity. Right? These things don't exist in a vacuum. Right? There have to be, some type of sensors. There have to be some kind of hardware that's running on operating systems that it's interacting with, other software it's interacting with, and those produce unexpected effects. Right? So, one of the famous examples that's gotten a lot of press or a lot of discussion that I mentioned in the paper, which is kind of unsavory, but Google's photo image recognition system began labeling pictures of black individuals, African descent individuals, as gorillas, which number one is offensive. Number two is problematic because they don't know why it did it. Was it some bias in the data that was being fed? Was it some bias in the design of the system? Nobody knows why it started doing this. And for my purposes, the major question, the major takeaway was, since nobody knew why it was doing it, there was no way to fix it. Right? You can't go in and say, okay, if we tweak this or fix this thing, it will stop offensively labeling these pictures as gorillas. The only thing they could do was prevent the system from labeling any picture as a gorilla, right? Because you don't know where to go. And there are actually a number of examples like this. The machine doesn't know it's being offensive, right? The machine just is doing whatever machines do. Whether we can figure out what it's doing is a different question. So all of that makes the system opaque, right? It's certainly not unbiased, but we may not understand exactly what it's doing. leading you to the calculated public's outcome that I'm interested in. And here's sort of the reason I'm interested in it, or what I think gives us some historical sense. Standards are hard to figure out, right? Whether something is reasonable, whether something is a fair use. So in 1976, when the U.S. Copyright Act was enacted and fair use was put into the statute, a bunch of the stakeholders got together to talk about fair use in the photocopying area. It was a very big concern at the time, it still is somewhat of a concern, that educational materials would be photocopied and made available to students without paying royalties or without permission of the copyright holder. Now, it's presumably fair use to do some type of educational provision of materials to students, but you won't know what that is until a judge balances the factors and tells you. So the publishers and the educators sat down and they came up with a series of so-called fair use guidelines. Right? And these are some of the guidelines. Right? They basically said, we will deem it fair use. We will not sue each other. If a teacher either uses a complete poem of less than 250 words and printed on no more than 2 pages, or if you want to use a longer poem, you can take an excerpt of 250 words. We'll say that's okay. You can take a complete story, article, or essay of less than 2,500 words, or an excerpt from a prose work of not more than 1,000 words, or 10% of the work, whichever is less, but in any event, you're allowed to take 500 words, and we'll say that's okay. And notice this is not fair use. Right? This is not balancing any of the 4 factors in the statute. This is just people sit down and said, we're going to say this is all right. You know, we're not going to fight each other if you take 250 words from the poem, or if you take 2,500 words from the story. And this was not enacted into law. It was not even approved of by the legislature. This was just what some educators and publishers sat down and they reported to Congress. As we've come to an agreement that we won't, beat each other up if people stay within these guidelines. What do you suppose happened? Well, these started showing up in court, right? When publishers and educators sued each other for photocopying, they would say, he took more than 250 words. Or the judge looking for some sort of indicator or criteria as to whether these was fair, would say, oh, well, you guys agreed, you'd take 2,500 words or less, and you took more than that, so I'm thinking maybe this wasn't fair. Again, despite the fact that this wasn't law or enacted into law, it was nothing more than a stakeholder agreement. Notice, number one, this is the kind of thing that's discrete. It's a discrete rule rather than a standard. Right? It's easy to understand. Right? I can count up to 250. I might not know if something was reasonable, but I can count up to 250. And you could probably program this. Right? But, you can design an algorithm that counts up to 250 or 2,500. So this became very appealing. It started showing up in court cases, right? Being adopted as sort of a de facto standard in some photocopying cases as to what might be fair, right? The indicators that we have, right, from what's happening right now with copyright enforcement through algorithms, the historical experience from these fair use guidelines, and what we know about calculated publics, the creation of calculated publics, suggests that if you try and embed something like a fair use detector, right, or a copyright exception detector in algorithm, you're not going to be able to capture what the law does, right, because the law is complex, and we just talked about the limitations of the technology. You can put something in there that might approximate it or might make it take a stab at it. And if you do that, that's going to shift the expectation of the public, probably the expectations of courts, Because that's easier to understand than going through the process of trying to figure out, oh, was this reasonable? Was this an educational use? Does this meet the balancing of the four factors? That's what Tarleton Gillespie means by the creation of the calculated public, right? Is that the interaction of the public with the algorithm changes what the public expects, changes public behavior. And so, by trying to put some sort of abbreviated or bowdlerized exception, right, some approximation of fair use into the algorithm, what we know about interaction with algorithms suggests that will change the standard. And you will end up with whatever it was that you built into the system becoming the new standard for fair use or the new standard for the exception. Rather than capturing what the law has done or what the goals of the law were. Now, I end up on kind of a pessimistic note. Right? Neva Elkin-Corin told you, I think, or said here, I think, back in the spring, at least this is what she said at UCLA when she gave the talk, that if we don't somehow incorporate fair use into these algorithms, we're going to continue to have the outcome that Matt Sagg has told us about, which is it's just a de facto finding of infringement when there's a match and no one takes fair use into account anymore. That's probably right. On the other hand, if you try and build fair use into the system, you then change the standard for fair use to where you don't get fair use anymore. Now what you get is whatever approximation you built into the system, and that's what people expect, that's what judges begin to expect. Right? Under neither of those scenarios does fair use or this type of standards-based exception survive in the algorithm society. That's kind of depressing. But it shouldn't surprise us. Right? We've known for some time that copyright is not working well in the digital environment. So rather than try and put, sort of a, what's the word for plaster on the, little sticking plaster over a gigantic wound, we probably need to go back and rethink the whole system. Right? We're not going to be able to salvage these exceptions by trying to build them into algorithms. If we're going to deal with the algorithm society, we probably need to rethink copyright from the ground up. Right? And that's a big project, but the idea of algorithmic fair use is almost an oxymoron. Right? We can't capture fair use in algorithms, and if we try, we're going to get something that's not fair use. Okay, let me stop there. I think that's about the time that I was told to bend your ears and think about details, problems, clarifications, and so on.
All right, thank you very much, Dan.